No humans were harmed or even used in the creation of this program. We created it from a script written by the presenter using a generative artificial intelligence platform. We hope you enjoy it. Welcome to today's program, the latest guidance on using generative AI in your practice. My name is McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I am speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Our topic today is AI and how this technology, particularly the species known as generative AI, or GAI for short, that can generate content in the form of text, images, video, and audio in response to prompts from a user, is already changing how lawyers do our jobs. In a nutshell, how does GAI work? There are highly technical explanations, but for lay people that includes most lawyers, let me offer a few common sense analogies. GAI works by predicting the next word or token based on sequence of words in the prompt. One way to think of this is that it is like autocomplete on steroids. You've no doubt seen autocomplete work when you are composing emails or texts to predict the ending of words or phrasing that you start. GAI takes this to a whole other level by predicting the answer to questions that you ask, which seems to the user like the chatbot is answering the question. GAI is able to do this by using neural networks that are loosely based on the architecture of our brains, but in this case, each neuron is connected to many other neurons. GAI tools are then trained to predict the next word by calibrating the strength of the connections between neurons to minimize prediction errors, much like calibrating coefficients in a regression. I hope that gives you some sense of how GAI work without causing your eyes to roll back in your head. Another absolutely key takeaway: you must never forget that GAI tools are not humans, and they have no concept of truth, no values, and no reflection. Because GAI has no concept of truth, if a GAI tool provides you with an answer that isn't accurate, that is because the tool had no way to distinguish it from an accurate one. The GAI tool served up the answer it did because your prompt correlated best with that answer, even if the answer turned out to be wrong. As a commentator aptly put it, ChatGPT-3 is currently the opposite of a lawyer. ChatGPT delivers wrong answers with a high degree of confidence. Good lawyers deliver well-researched information with a substantially moderated level of confidence, couching answers with maybe and probably and it depends. Lawyers are highly self-conscious about the consequences of being wrong, and even more aware of the potential disaster that giving a wrong answer confidently could have on their case, their client, and their law license. ChatGPT, meanwhile, does not know or care if it is wrong. 2 years ago, in a program entitled Understanding and Managing Generative AI Legal Practice Risks, I explained what GAI is, how it works, what it can do and what it can't, how reliable it is or isn't, and most critically, what legal ethics issues can arise when lawyers begin to use GAI in their legal practice. If you are looking for an introduction to this topic, I would recommend my prior program to you, which is likely available on the same service where you are viewing this one. To give you a preview, I covered 8 areas of legal ethics concerns for practicing lawyers. My goal was to provide lawyers with issue spotter guidance to evaluate specific GAI tools to ensure that whatever use you make of these tools in your practice complies with your legal ethics obligations. The 8 areas of concern I discussed are your ethical obligations to 1. Be competent, 2. Maintain client confidences, 3. Protect client property and data, 4. Be candid before the court, 5. Not bring frivolous claims, 6. Supervise non-lawyer staff, 7. Avoid the unauthorized practice of law, and 8. Not discriminate against others on the basis of protected characteristics. Because I did an introductory program on GAI, I am not going to spend much time today going over the basics. Instead, I will focus on the main ways that lawyers are using GAI tools in their practices today and the latest guidance the ABA and influential bar associations in California and New York have issued on how to use this technology without violating our obligations under the legal ethics rules. So, what has happened in the last 2 years as it relates to GAI and the practice of law? Well, a lot has happened. First, more lawyers than ever before are using GAI in their practices, and this is true across lawyers in private practice, in-house, and government. Earlier this year, the Thomson Reuters Institute issued its 2025 Generative AI and Professional Services Report based on a survey of 1,700 professionals in the United States, Canada, the United Kingdom, Australia, Brazil, New Zealand, Argentina, and Mexico. The participants included lawyers working in corporations, law firms, and in government, and it is from those responses that the report drew its conclusions about the use of GAI in the legal profession. The report had 5 key findings that I assume will not shock you given the unrelenting buzz around GAI, but I think you will find 1 or 2 of them interesting and perhaps surprising. Here are the 5 key findings presented by some of our legal colleagues.
First, steady usage of GAI increases. 41% of respondents said they personally use publicly available tools such as ChatGPT, and 17% said they personally use industry-specific GAI tools. On an organization-wide level, the percentage of respondents who said their organizations were actively using GAI nearly doubled over the past year to 22% in 2025 compared to 12% in 2024. An additional 50% of respondents said their organizations are either creating plans to use GAI or deciding whether or not to do so.
Again, not surprising given how much we hear in the news about the potential GAI has to transform all industries, and how much we hear and read in the legal press about how much GAI can help lawyers practice law more effectively and efficiently. It stands to reason that more and more lawyers are going to give it a try in the hope of realizing these benefits for themselves and their clients. As you might expect, this interest in exploring ways in which GAI tools can help lawyers also has led to a growing body of continuing legal education programs on this topic, which is also a very good thing.
Second, GAI adoption has been steady thus far. Many respondents said they expect its use to increase quickly. Just 13% say GAI is central to their organization's workflow currently, but an additional 29% believe it will be central within the next year. Further, 95% of all respondents believe it will be central to their organization's workflow within the next 5 years.
At the risk of dating myself, this finding reminds me of how email became an integral part of the practice of law in the late 1990s. At first, law firms were cautious about email because it was a new technology that came with the risk that client confidential information could be inadvertently disclosed with the push of a button, so adoption was slow at first. But the stair-step leap in efficiency that email delivered, for example, being able to email a client a draft of a brief rather than having it messengered to an office or sent by facsimile, was too great for lawyers and clients to ignore, and so adoption of email by lawyers was practically universal in just a year or two. I believe we are seeing the same thing happen with GAI and that it will be central to every lawyer's workflow within 3 years, if not before, just like email is now. To my mind, GAI is just the latest technological innovation, following in the footsteps of electronic legal research services, electronic case filing, Zoom or Teams platforms for court appearances and depositions, and many other advancements that is just too beneficial in terms of efficiency and cost savings that it is destined to become a key part of how lawyers practice law in 2025 and beyond.
Third, professionals in general are maintaining positivity. 55% of all respondents categorize their sentiment towards GAI in their profession as excited or hopeful. Meanwhile, the proportion who said they were hesitant, concerned, or fearful fell 12 percentage points over the past year. More than 60% also said GAI actively should be used for work in their industry, and 89% said they believe they can see GAI use cases in their own work.
I attribute this finding of less fear around GAI to more and more lawyers having had an opportunity to try out the technology for themselves. Everyone fears the unknown, and so having the opportunity to enter some queries for yourself into Google Gemini or Perplexity or whatever GAI platform you choose will give you a better sense of what we are talking about than you can get from listening to people like me talking to you about GAI. After you give GAI a try, you will quickly recognize that GAI isn't going to make lawyers obsolete, as many have feared, but it will change how we do our jobs. I believe these changes will be a net positive for the legal profession and for our clients, as long as we use GAI responsibly and in ways that don't cause us to violate our legal ethics obligations. Of course, that is the main objective of today's program, to give you the latest guidance from the ABA, California, and New York to help you do exactly that. Thankfully, we have that guidance being issued relatively soon after GAI tools have become readily available to lawyers versus other situations where the practice of law evolved rapidly. Think about the explosion of lawyers working remotely during and after COVID, before the ABA and other state bar associations caught up by enacting updated rules regarding the unauthorized practice of law to address remote work. Hopefully, the transition to using GAI tools in our practice will go smoother than the transition to remote work, because we are getting ample guidance from the ABA and other bar associations on the front end rather than after the fact.
Fourth, business questions remain, even with these strong usage increases. However, few are yet realizing the business impact of GAI. Only 20% of respondents said they knew their organizations were measuring return on investment of GAI, and many firm respondents remain unsure about its impact on rates or client costs. For their part, a majority of clients want their firms to be using GAI, but 71% of law firm clients said they did not know whether their outside firms were doing so or not.
This one is interesting, particularly as it relates to how lawyers charge for our services. We'll talk about billing and legal fees a bit later, what is permissible as it relates to the use of GAI and what is not. But just noting for now that both lawyers and clients want lawyers to use GAI to provide their services more efficiently and at a lower cost, and that currently no one has a very good idea of exactly how GAI is making its way either into a law firm's cost to serve or into the bills that are issued to its clients. This has to change both, because law firms will want to measure their productivity gains from the use of GAI tools, just like they measure things like how much it costs whenever an associate leaves the firm in terms of the need to replace that lawyer, and because clients will begin to demand more transparency in terms of what their law firms are doing to lower their legal bills once the use of GAI tools in the practice of law becomes a need to have instead of a nice to have. Thankfully, law firms have reams of data in the form of billable hour records of their lawyers going back decades that can be mined by GAI tools to figure out just how much more efficient their lawyers have become in performing certain tasks, such as document review, legal research, and document summarization, to show the productivity gains the law firm is realizing by using GAI tools to assist with these tasks. I suppose that is one of the benefits, and perhaps the only benefit if you hate keeping track of your billable hours, of requiring lawyers to track our time in 6-minute increments for all of those many years.
Finally, most respondents believe that policies and training are still needed. The rise in general GAI usage also has not translated to widespread guardrails around its use. More than half of respondents said they believed their organizations had no policies around GAI at work, whether a standalone policy or as part of a larger technology policy. Nearly 64% meanwhile said they had received no GAI training at work.
2 comments on this. First, policies that govern our use of GAI already exist for all lawyers, and they are called the legal ethics rules. Whether your law firm, company, or government agency yet has taken the opportunity to show you how the legal ethics rules can apply in the context of using GAI in your practice, those rules exist. You are required to follow them, and there can be serious consequences for any lawyer who is found to have violated them. Once again, that is what this program is endeavoring to do, namely to give you the guidance you need to allow you to use GAI in your practice while avoiding common traps for the lurking in the legal ethics rules. I already mentioned the increase in continuing legal education programs on this topic, stemming from increased demand among lawyers for training in this area. Second, even if a use of GAI doesn't violate the legal ethics rules, organizations still need to have policies and procedures in place to ensure that its lawyers use the technology in a way that lives up to the standards of that organization. If, for example, a law firm uses GAI to assist with legal research, the result, if done irresponsibly, might or might not be an ethical violation, but either way, it might result in embarrassment and loss of business for the lawyers involved. The same is true if a law firm uses a GAI tool to assist with document review, in lieu of or as a way to supplement the review conducted by more junior lawyers, and that results in a privileged document inadvertently being produced to the other side in a litigation. The same thing for using a GAI tool to summarize a key contract or deposition transcript. If things end up being missed or erroneous information included in those summaries, the result will be embarrassment for the lawyers and the law firm, whether or not it also constitutes a violation of the legal ethics rules. Policies, procedures, and training should be used to mitigate the risk of that occurring. The second major development in the last 2 years is the issuance of new guidance for lawyers on the use of GAI in our practices. In July 2024, the ABA Standing Committee on Ethics and Professional Responsibility issued Formal Opinion Number 512 entitled Generative Artificial Intelligence Tools. This formal ethics opinion, which will be highly influential, albeit non-binding guidance for all lawyers who practice in states that have legal ethics rules modeled after the ABA model rules, represents a huge step forward in identifying the legal ethics issues that can arise when lawyers use GAI and providing guidance on how to navigate those issues. As a result, we will go through Formal Ethics Opinion Number 512 in detail today, not in the abstract, but in the context of the most common ways that lawyers are using GAI in their law practices today. Hopefully, examining the ABA's guidance in the context of the ways that GAI is actually being used by lawyers will help you to digest it and apply it to your own practice as you contemplate or perhaps are already engaging in those same activities. We'll also cover off the guidance issued around the same time by influential bar associations in California and New York. While that guidance largely dovetails with the views expressed by the ABA in Formal Ethics Opinion Number 512, it is important for lawyers who practice in those two states to be aware of these authorities and to take time to read them for yourselves to capture any state-specific nuances. None of this guidance was available when I did my introductory program 2 years ago on the use of GAI in the practice of law, and I can tell you what a benefit it is to have that guidance available to us now. I don't think usage of GAI tools is exploding because we now have more guidance from the ABA and these influential state bars. I believe such usage was destined to increase anyway. But it is fortunate that we can consult that guidance whenever a new potential use case emerges, so that we can stay ahead of the curve in terms of thinking about potential legal ethics issues. While it's certainly possible to reason by analogy by looking at older technologies such as the dawn of email, or even the photocopier when trying to spot legal ethics issues that a new use case involving a GAI tool likely raises. You will see a bit of this reasoning by analogy when we dig into the ABA's guidance in Formal Ethics Opinion Number 512. But it is much better for the ABA to have had some concrete use cases involving GAI tools in mind when they were promulgating their guidance. While you can never anticipate everything, at least when the ABA is giving guidance about using GAI tools for legal research, it is talking about an actual real-life use case that lawyers are dealing with right now in 2025, and not some hypothetical. The final thing that has happened in the past 2 years is that we've seen a few more horror stories of lawyers who have gotten themselves in trouble by misusing GAI in their law practice. The first and still most famous example was the personal injury lawyer in New York who was sanctioned by a Manhattan federal district judge in early 2023 under Rule 11 of the Rules of Civil Procedure for submitting an affirmation in response to a motion to dismiss that cited 6 federal court decisions that did not in fact exist. The lawyer asked ChatGPT to provide him with case law support for the argument he was making, and ChatGPT simply made up the cases. Each case had party names, a docket number, a reporter citation, and text that purported to be the opinion of the court, but they were fake. The lawyer didn't do anything to confirm that the cases were real before he submitted them to the court, basically claiming that he thought the results from ChatGPT were the same as results you would find by researching the same issue on Westlaw or Lexis. Needless to say, the federal judge who sanctioned him did not see it that way when he decided to impose what were the first ever sanctions for submitting fake cases generated by ChatGPT to a court. That was a case of first impression that I found so fascinating that I made it the subject of its own CLE program entitled Legal Ethics: The ChatGPT Lawyer Sanctions Case, that you can watch if you are interested in learning more about it. Since that time, we've seen 2 other cases make the national headlines where lawyers similarly cited cases they found using GAI tools that did not exist in briefs filed with federal courts. The first case occurred in late 2023, and it involved disbarred lawyer Michael Cohen, who became famous, or rather infamous, as President Donald Trump's personal lawyer who handled the hush money payment to porn star Stormy Daniels. Cohen was disbarred after he pled guilty and served time in prison for tax evasion and making false statements to a bank. In a bid to end his supervised release early, Cohen's current lawyer, David Schwartz, filed a motion in the U.S. District Court for the Southern District of New York that included 3 cases that did not exist. It turns out that Cohen found those cases using Google's Gemini GAI tool, sent them to Schwartz, who failed to check the cases before submitting them in a brief he filed with the court. Needless to say, U.S. District Judge Jesse Furman was not amused and issued an order to show cause why Schwartz should not be sanctioned under Rule 11. Following briefing and a hearing on the OSC, Judge Furman acknowledged that the citations were, quote, embarrassing and certainly negligent, perhaps even grossly negligent, end quote, but he ruled that they were not made in bad faith. Schwartz and Cohen later apologized for the error. For Cohen, this is just the latest twist in the dumpster fire that has become his life following his work for President Trump and his criminal convictions. But for any other lawyer, an event like this could put a black mark on an otherwise distinguished legal career, so it is worth pausing for a moment to consider it as a cautionary tale. The other case that made headlines, this time in an opinion in the Second Circuit Court of Appeals issued in January 2024, involved attorney J.S. Lee, who filed a reply brief in the Second Circuit that cited a case that did not exist. Lee explained that she had used ChatGPT to find cases establishing a minimum wage for an injured worker when she had difficulty finding such a case through other sources, and that, unbeknownst to her, ChatGPT had invented just such a case that she, in turn, cited in her reply brief without verifying it. After noting that all attorneys are required by New York Rule of Professional Conduct 3.3, candor before the tribunal, and Rule 11 to ensure that any cases they cite to a court are legally tenable, the Second Circuit referred Lee to the court's grievance panel for further investigation and possible referral to the Committee on Admissions and Grievances for possible sanctions. The court also ordered Lee to provide a copy of its opinion to her client. Hopefully, this program will help you to ensure that you are always on the right side and never on the wrong side of the lines established by the legal ethics rules and Rule 11 as it relates to the use of GAI in your law practice. With that introduction, let's get into it. On the bright side, we now have guidance from the ABA on how to use GAI in our practices in ways that don't cause us to violate the legal ethics rules. On the dark side, we have so much guidance that it would take several programs like this to walk through it all. And even if we took the time to do that, it would be mind-numbingly dull taking you through everything the ABA said in Formal Opinion number 512. The other challenge we face is that there are so many different ways that lawyers are using GAI today, with more being added constantly, that we could never discuss all of them in enough detail to give you the guidance you need with regard to any particular use case. Because we can't boil the ocean, and we wouldn't want to even if we could, the approach I am going to take is to discuss the ABA's guidance as it relates to each of the top 3 ways that lawyers are using GAI in our practice today. By using the 2 most common use cases as our examples, we can cover the relevant ABA guidance in enough depth that it should give you what you need to apply that guidance should you choose to use GAI in any of these ways in your own practice. It also helps immensely to have a specific use case in mind when you are thinking about the ABA's guidance with regard to a particular rule or ethical obligation, such as the duty to preserve client confidential information under ABA Model Rule 1.6, rather than trying to absorb that guidance in the abstract. So, what are the top 3 use cases of GAI by lawyers in 2025? For that, we return to the Thomson Reuters Institute and its 2025 Generative AI and Professional Services Report. That survey found that the top use cases for lawyers, which were defined as those use cases that were cited by 50% or more of legal professionals, both in private practice and in government as currently in use in their organizations, are the following. Number 1, document review. Number 2, legal research. And number 3, document summarization. Let's review each of these use cases in turn, first by describing a bit of what the use case involves, how that use case differs from how we practiced law before we had GAI tools, and then how the ABA's guidance applies to that use case. Of course, some of the ABA's guidance will apply to more than one use case, but I think organizing our discussion of that guidance around the top 2 use cases will be a good way to proceed. That said, just because I don't discuss the duty to preserve client confidences in connection with the first use case as an example, you shouldn't understand that to mean that duty doesn't apply to that use case. That duty, as with all of our obligations under the legal ethics rules, applies to everything we do when we practice law. I am just choosing to emphasize the legal ethics obligations that should be top of mind when using GAI to assist you with a particular task on behalf of a client, such as document review. Let's start with number 1, document review. Let's hear from one of our legal colleagues on how GAI is being used in connection with document review.
Before GAI, document review was a painstaking, manual process. I'd spend countless hours, often with a team of junior lawyers and paralegals, reading through thousands of pages line by line. We'd tag documents for relevance or privilege by hand, summarize key points in separate notes, and double-check each other's work to avoid mistakes. It was slow, expensive, and honestly, pretty exhausting, especially when we had to sift through mountains of emails, contracts, and scan files using nothing more than spreadsheets or basic document management systems. Now, with GAI, the process is almost unrecognizable. I can upload a massive batch of documents and let the GAI quickly sort, tag, and even summarize them, highlighting what's relevant and why. Instead of spending weeks on initial review, I get concise summaries and extracted data in hours, which means I can focus on strategy and client advice. It's made my work faster, more accurate, and much less tedious.
The adoption of GAI tools for document review is significantly transforming the practice of law by enhancing speed and accuracy in processing large volumes of material. In traditional discovery, attorneys and paralegal teams laboriously sifted through vast quantities of emails, contracts, and business records to identify key documents and privileged information, a process prone to fatigue and human error. Now, GAI-powered review platforms can rapidly classify, cluster, and prioritize documents based on relevance, privilege, or responsiveness, allowing legal professionals to focus resources on critical files and significantly compress the review timeline. GAI tools for document review are also advancing the sophistication and defensibility of legal work product. These systems are capable of not only sorting and flagging documents, but also learning from attorney review decisions to better identify patterns and surface similar content. As a result, legal teams benefit from a form of augmented intelligence, where the technology amplifies expertise and increases the likelihood of discovering crucial facts, patterns of behavior, or smoking gun documents. The net effect is an improvement in both the thoroughness and efficiency of discovery, particularly in complex or high-stakes litigation and regulatory matters. But of course, all of these benefits don't come without a significant increase in risks, including potential violations of our legal ethics obligations. The first legal ethics obligation to consider with this and any other use case involving GAI is the duty of competency. ABA Model Rule 1.1 provides, "A lawyer shall provide competent representation to a client." Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. In Formal Opinion Number 512, the ABA noted that this duty includes the obligation to understand the benefits and risks associated with the technologies used to deliver legal services to clients. Lawyers may ordinarily achieve the requisite level of competency by engaging in self-study, associating with another competent lawyer, or consulting with an individual who has sufficient expertise in the relevant field. To competently use a GAI tool in a client representation, lawyers need not become GAI experts. Rather, lawyers must have a reasonable understanding of the capabilities and limitations of the specific GAI technology that the lawyer might use. This means that lawyers should either acquire a reasonable understanding of the benefits and risks of the GAI tools that they employ in their practices, or draw on the expertise of others who can provide guidance about the relevant GAI tools' capabilities and limitations. What this requires of lawyers who use GAI to assist with document review is first to understand how the technology works in this context and what its limitations are. At the highest level, loading thousands of documents into a GAI tool, allowing that tool to sort, tag, and summarize them, highlighting what's relevant and why, and then relying completely and exclusively on that output to guide your representation of your client would create a high risk that you will be violating your duty of competence. Why is that? Because no GAI tool is 100% accurate, and depending on the context, it might not even be 50% accurate. GAI tools are error-prone for many reasons, but the two most salient ways that they tend to err stems both from what is being input into the tool and what the tool is outputting to you. When you begin to use GAI for yourself, maybe typing simple questions into Google Gemini like, "What airlines fly direct from Airport X to Airport Y?" You'll quickly discover that often you need to rephrase or reframe your question to get the answer you seek. For example, you might need to specify commercial airlines to exclude FedEx or UPS planes from the list the GAI tool returns. Any human being would understand your original query to be focused on commercial airlines, but a GAI tool might or might not appreciate that nuance. For the same reason, a request to tag all documents that are, quote, board minute send, quote, as potentially confidential or sensitive or privileged, so that they receive a second review by a senior associate, might miss a few. For example, a board document entitled Action on Written Consent. The point is that asking GAI to tag all board minutes isn't the same as asking a junior associate or contract attorney to tag all board minutes, and you need to be aware of that. The second source of error arises from the outputs of GAI tools. As we saw from the horror stories of the lawyers who cited cases in briefs that did not in fact exist, GAI tools can create things out of whole cloth. Sometimes these errors are described as hallucinations, but AI experts don't like to use that term, and I agree that it isn't a good analogy because it's less that the GAI tool is suffering from some sort of fever dream that causes it to see things that aren't there, and instead, it's the GAI tool's eagerness to please its user that produces the error. Think of your dog when you ask it to fetch you a stick. Maybe 9 times out of 10, your dog dutifully returns with a stick, but 1 time in 10, it brings you one of your shoes. Your dog is so desperate to please you that it isn't going to come back empty-handed when it can't find the stick, so it brings you something else that it thinks you will like. GAI tools are better at this than dogs are. If it can't find you a case that establishes a minimum wage for an injured worker, as Attorney Lee asked it to do in one of our horror story cases, it creates one with party names, a case number, a court, and a summary of the opinion, and serves it up to you rather than show up empty-handed. And because it brings you something that looks like a stick and not a shoe, the temptation is to believe that the stick is real without verifying it, and that is what has gotten these lawyers in trouble under the legal ethics rules in Rule 11. Indeed, if you work in a large law firm, company, or government agency, it's possible you already have encountered GAI policies that your organization has implemented whether you notice them or not. Many organizations have begun to block their employees from accessing generally available GAI using web browsers to prevent them from misusing the technology by, for example, entering confidential information into these tools, and to give themselves time to figure out how they will allow their employees to use GAI tools and to train them on those new policies. These organizations have been made aware of the horror stories we discussed at the outset, and they want to prevent their lawyers and organizations from being the next headline. So if GAI tools aren't 100% reliable both because of what you are asking them to do and because of what they are providing in response, why are more and more lawyers using them for important tasks like document review? Shouldn't we all be sitting on the sidelines and saying, I'm not going to go near this thing until it's 100% accurate? No, because there is another aspect of the duty of competence that actually requires lawyers not to bury their heads in the sand and ignore GAI tools entirely. Comment number 8 to ABA Model Rule 1.1 provides, to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engage in continuing study and education, and comply with all continuing legal education requirements to which the lawyer is subject. As someone who produces a fair amount of continuing legal education programs, I certainly won't argue with the ABA reminding lawyers to comply with their CLE obligations. On a more serious note, as we just saw, the ABA echoed the obligation to keep abreast of new technologies in Formal Opinion number 512, specifically in relation to GAI tools. Remember my earlier story about the early days of email? Responsible lawyers didn't ignore the technology, but rather they studied it carefully and only incorporated it into their legal practice once they could be confident that they were taking the necessary precautions to minimizing the risks of using email. Fast forward 30 years, and I think you could argue that any lawyer that doesn't use email for client work, at least in cases where it benefits the client, isn't fulfilling his or her duty to provide competent representation. Perhaps a better example is a lawyer who insists on verifying the accuracy of cases by shepherdizing them using the actual books because he doesn't know how to use Westlaw or Lexis. I don't even know if they make the Shepherd's books anymore. I think the last time I saw one was my first year of law school, and that was a very, very long time ago. But I think you see the point. A lawyer can't fulfill his or her duty of competency that includes the duty to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology by ignoring new technologies like GAI. And as we alluded to earlier, more and more clients are demanding that their lawyers use GAI tools to provide more efficient and less costly representation. So if you were to ignore GAI completely, you can bet you will lose clients to law firms that take the opposite view. Bottom line, lawyers are being required by client demands and to a lesser extent by the requirements of ABA Model Rule 1.1 to stay abreast of new technologies, to use GAI tools that everyone knows are not 100% reliable, while at the same time continuing to provide legal representation and advice that is 100% accurate to the best of the lawyer's ability. How exactly are we supposed to thread that needle? Here is where the ABA's latest guidance is very helpful. Because GAI tools are subject to mistakes, lawyers' uncritical reliance on content created by a GAI tool can result in inaccurate legal advice to clients or misleading representations to courts and third parties. Therefore, a lawyer's reliance on or submission of a GAI tool's output without an appropriate degree of independent verification or review of its output could violate the duty to provide competent representation as required by Model Rule 1.1. While GAI tools may be able to significantly assist lawyers in serving clients, they cannot replace the judgment and experience necessary for lawyers to competently advise clients about their legal matters or to craft the legal documents or arguments required to carry out representations. The appropriate amount of independent verification or review required to satisfy Rule 1.1 will necessarily depend on the GAI tool and the specific task that it performs as part of the lawyer's representation of a client. For example, if a lawyer relies on a GAI tool to review and summarize numerous lengthy contracts, the lawyer would not necessarily have to manually review the entire set of documents to verify the results if the lawyer had previously tested the accuracy of the tool on a smaller subset of documents by manually reviewing those documents, comparing them to the summaries produced by the tool, and finding the summaries accurate. Moreover, a lawyer's use of a GAI tool designed specifically for the practice of law or to perform a discrete legal task, such as generating ideas, may require less independent verification or review, particularly where a lawyer's prior experience with the GAI tool provides a reasonable basis for relying on its results. To summarize, you can use GAI tools to help you review documents, including sorting, tagging, and summarizing those documents, as long as you don't rely solely on the results produced by the tool without first doing an appropriate amount of independent verification and review of those results. Maybe that means if you are looking for board minutes, you query a few dates where you know board meetings occurred to make sure those minutes were sorted, tagged, and summarized accurately. Maybe you search for minutes of non-board meetings to make sure they were properly excluded from those results. Maybe you read a document summary of an important board meeting, and then you read the full board minutes to ensure that the summary is accurate and that it didn't leave anything out. If you find mistakes as a result of this process of independent verification and review, you make changes to how you are asking the GAI tool to sort, tag, and summarize the documents you uploaded and see if that fixes the mistakes and produces a better output. Maybe you make sure that all documents you plan to produce in a litigation are reviewed by a human being before you produce them. These are some things that you could do to make sure you are fulfilling your duty of competence under Rule 1.1 when using a GAI tool for document review. As the ABA opined, if you are using a bespoke GAI tool that is specifically created for legal document review, and you have used that tool in the past and it has proven itself to produce accurate results, maybe you need to do less in terms of independent verification and review. But if you are using a GAI tool that you've never used before, and maybe one that isn't designed specifically for legal document review, you probably need to do more in terms of independent verification and review. While all of this will depend on the type of GAI tool you are using and the type of case you are handling, I think this gives you a sense of what lawyers are required to do when they are using GAI tools for document review in order to fulfill their duty of competence under ABA Model Rule 1.1. To my mind, the guidance on this point set out in Formal Ethics Opinion number 512 is both reasonable and easy to implement, which isn't always the case with guidance from the ABA. On the one hand, you have complete, total, and uncritical reliance on the output of a GAI tool for document review, which is clearly prohibited by the legal ethics rules, and on the other hand, You have double-checking and manually verifying every output of the GAI tool, thus defeating the purpose of using the GAI tool to increase efficiency and lower costs, which is clearly not required by the legal ethics rules. If you can utilize a GAI tool to assist you with document review in a manner that keeps you in the happy middle between those two poles and more toward the cautious side with new GAI tools you haven't used before or that aren't specifically designed to help lawyers with document review, you should be fine from a legal ethics standpoint with regard to your duty of competence under ABA Model Rule 1.1. The second legal ethics obligation to consider with regard to using GAI for document review is the duty to supervise legal and non-legal personnel. ABA Model Rules 5.1 and 5.3 address the ethical duties of lawyers charged with managerial and supervisory responsibilities and set forth those lawyers' responsibilities with regard to the firm, subordinate lawyers, and non-lawyers. The ABA summarized those duties as they relate to the use of GAI tools by lawyers and non-lawyers in Formal Opinion Number 512 as follows. Managerial lawyers must create effective measures to ensure that all lawyers in the firm conform to the rules of professional conduct, and supervisory lawyers must supervise subordinate lawyers and non-lawyer assistants to ensure that subordinate lawyers and non-lawyer assistants conform to the rules. Managerial lawyers must establish clear policies regarding the law firm's permissible use of GAI, and supervisory lawyers must make reasonable efforts to ensure that the firm's lawyers and non-lawyers comply with their professional obligations when using GAI tools. Supervisory obligations also include ensuring that subordinate lawyers and non-lawyers are trained, including in the ethical and practical use of the GAI tools relevant to their work as well as on risks associated with relevant GAI use. Training could include the basics of GAI technology, the capabilities and limitations of the tools, ethical issues in use of GAI, and best practices for secure data handling, privacy, and confidentiality. Similar to the lawyers who are engaged in the process of document review and who cannot simply take the results of that review produced by GAI tools and run with them as we discussed before, managerial lawyers cannot simply take the results handed to them by more junior lawyers who are using GAI tools and run with them. Doing so would violate the duties of those managerial lawyers to supervise and train more junior lawyers under ABA Model Rules 5.1 and 5.3. What those rules require in this context is that the managerial lawyers provide sufficient guidance in the form of clear policies regarding the law firm's permissible use of GAI and make reasonable efforts to ensure that the firm's lawyers and non-lawyers comply with their professional obligations when using GAI tools. In addition, managerial lawyers must provide sufficient training on the ethical and practical use of the GAI tools relevant to their work, as well as on risks associated with relevant GAI use, which may include the basics of GAI technology, the capabilities and limitations of the tools, ethical issues in use of GAI, and best practices for secure data handling, privacy, and confidentiality. If managerial lawyers do these two things, the ABA guidance suggests that they will have met their ethical obligations under ABA Model Rules 5.1 and 5.3 as it relates to the use of GAI tools by the law firm. I mentioned at the outset that in addition to the ABA's Formal Opinion Number 512, influential bar associations in California and New York also issued guidance around the same time. On November 16, 2023, the State Bar of California Standing Committee on Professional Responsibility and Conduct issued a document entitled Practical Guidance for the Use of Generative Artificial Intelligence in the Practice of Law. On August 7, 2024, the New York City Bar Association Committee on Professional Ethics issued Formal Opinion 2024-5 entitled Ethical Obligations of Lawyers and Law Firms Relating to the Use of Generative Artificial Intelligence in the Practice of Law. I have included copies of these publications in the written materials for this program, and if you practice in either of these states, I encourage you to read them. While each is broadly consistent with the ABA's guidance in Formal Opinion Number 512, it is important for lawyers who practice in those two states to be aware of these authorities and to take time to read them for yourselves to capture any state-specific nuances. In that regard, both the California and New York guidance emphasize a point relating to managerial and subordinate lawyers that the ABA didn't cover in Formal Opinion Number 512. Specifically, both authorities point out that a subordinate lawyer must not use generative AI at the direction of a supervisory lawyer in a manner that violates the subordinate lawyer's professional responsibility and obligations. Put another way, a subordinate lawyer cannot escape liability for a violation of the legal ethics rules by claiming that he or she was acting at the direction of a supervisory lawyer. Accordingly, it is the responsibility of all lawyers, supervisory and subordinate, to ensure that any GAI tools they use are being used in a manner that satisfies the lawyer's obligations under the legal ethics rules. An important corollary to this duty is the obligation emphasized in the New York guidance, but not by the ABA or the California State Bar, of a subordinate lawyer to disclose to a supervisory lawyer the use of GAI that is not generally understood to be routinely used by lawyers. In order for a supervisory lawyer to fulfill his or her ethical obligations to vet a GAI tool before it is used for client work, the supervisory lawyer first needs to be aware that the tool is being used. As a result, subordinate lawyers have a duty to bring to the supervisory lawyer's attention if the subordinate lawyer intends to use a GAI tool for a certain function, if it is not a tool generally understood to be routinely used by lawyers for that function. The example the New York City Bar Association gives to flesh out this scenario is a subordinate lawyer choosing to use a GAI chatbot for client intake purposes. Because GAI chatbots are not generally understood to be routinely used by lawyers for client intake, the subordinate lawyer would have a duty to inform his or her supervisor that the subordinate lawyer intends to use a GAI chatbot to perform that function. This makes sense because there is a high likelihood that ethical problems may arise from using a GAI chatbot in this context. For example, a chatbot may fail to disclose that it is not a lawyer, or may attempt or appear to provide legal advice, increasing the risk that a prospective client relationship or a lawyer-client relationship could be created. Because of these risks, a high degree of supervision likely would be required both by the subordinate lawyer and the supervisory lawyer to ensure that the GAI chatbot was performing as intended and not violating any of the rules designed to prevent it from inadvertently creating a lawyer-client relationship. As we learned from ABA Model Rules 5.1 and 5.3 and the guidance we have been discussing, both the supervisory and subordinate lawyers would need to satisfy themselves that a GAI chatbot could be used to assist with client intake in this manner without violating the lawyer's ethical obligations. Another example would be using GAI tools to draft legal memoranda or briefs that are being passed on to more senior lawyers and/or clients for review. Because GAI tools are not generally understood by lawyers to be used for that function, at least not yet, and hopefully not anytime soon because of the risks of error we discussed earlier, a lawyer using GAI tools for that task would need to disclose that use to a supervisory lawyer, and failure to do so would violate the more junior lawyer's obligations under ABA Model Rule 5.1. So for all of you junior lawyers out there, while I recognize the temptation to use GAI tools to draft that memo or brief, you should resist that urge both because it would mean passing off work that is not your own, which is unethical in the general sense of the word, and failing to disclose use of a GAI tool that is not generally understood to be used by lawyers for that task, which is unethical in terms of your specific obligations under the legal ethics rules. Believe me when I say that you don't want any part of either of those things, particularly as you are trying to build your law practice and your reputation as a careful and ethical member of the bar. Lawyers have additional supervisory obligations insofar as they rely on others outside the law firm, such as vendors, to employ GAI tools in connection with the legal representation. The ABA summarized the duty to supervise others outside the law firm in Formal Opinion Number 512 as follows. Model Rule 5.3b imposes a duty on lawyers with direct supervisory authority over a non-lawyer to make reasonable efforts to ensure that the non-lawyer's conduct conforms with the professional obligations of the lawyer. When outsourcing legal and non-legal services to third-party providers, lawyers must ensure, for example, that the third party will do the work capably and protect the confidentiality of information relating to the representation, including the importance of reference checks and vendor credentials, understanding vendors' security policies and protocols, familiarity with vendors' hiring practices, using confidentiality agreements, understanding the vendor's conflicts check system to screen for adversity among firm clients, and the availability and accessibility of a legal forum for legal relief for violations of the vendor agreement. These concepts also apply to GAI providers and tools. In addition, when considering a lawyer's use of a GAI tool that requires the disclosure and storage of information relating to the representation, lawyers should ensure that the GAI tool is configured to preserve the confidentiality and security of information, that the obligation is enforceable, and that the lawyer will be notified in the event of a breach or service of process regarding production of client information. Investigate the GAI tool's reliability, security measures, and policies, including limitations on the tool's liability. Determine whether the GAI tool retains information submitted by the lawyer before and after the discontinuation of services, or asserts proprietary rights to the information. And understand the risk that GAI tool servers are subject to their own failures and may be an attractive target of cyber attacks. Boiling this down, what does a managerial lawyer need to do to meet his or her obligation to supervise others outside the law firm, such as vendors who will be providing GAI tools or services to the law firm? The most basic obligation is to vet the vendors to make sure they can do the work capably and ensure that client information is protected. Check their references. Check their security protocols. Make sure that your vendor agreement gives your law firm the ability to seek relief in court in a competent jurisdiction, such as a state or federal court located in the United States if a problem arises. At the end of the day, vetting a GAI vendor is very similar to the vetting your law firm undoubtedly already does of cloud computing providers that store your law firm's confidential files and data. That is, whatever you need to do to ensure that those files and data would be kept safe and secure, and that your law firm would have adequate recourse in the event of a data breach and/or at the termination of your relationship with the vendor. You should think of vetting vendors offering GAI tools as presenting the same risks that you need to cover off before you begin to use vendors that offer cloud storage or similar services for client work. The second legal ethics obligation to consider with regard to using GAI for document review is the duty to supervise legal and non-legal personnel. ABA Model Rules 5.1 and 5.3 address the ethical duties of lawyers charged with managerial and supervisory responsibilities and set forth those lawyers' responsibilities with regard to the firm, subordinate lawyers, and non-lawyers. This is another area where both the California and New York guidance emphasize a point that the ABA does not in Formal Ethics Opinion number 512. Specifically, it is a lawyer's duty under ABA Model Rules 8.4 and 1.2d, and in California under California Business and Professions Code Section 6068A to comply with the law. Here is how the California State Bar Committee framed the concern. A lawyer must comply with the law and cannot counsel a client to engage or assist a client in conduct that the lawyer knows is a violation of any law, rule, or ruling of a tribunal when using generative AI tools. There are many relevant and applicable legal issues surrounding generative AI, including but not limited to compliance with AI-specific laws, privacy laws, cross-border data transfer laws, intellectual property laws, and cybersecurity concerns. A lawyer should analyze the relevant laws and regulations applicable to the attorney or the client. The New York City Bar Association's Formal Ethics Opinion 2024-5 is nearly verbatim in its guidance on this point. The upshot is that while you are vetting vendors that are providing GAI tools, you need to be thinking about more than accuracy of results and security of client confidential information. You also need to be thinking about AI-specific laws, privacy, and cross-border transfer laws, such as the GDPR in the EU and the CCPA in California, to name but two examples, intellectual property laws and cybersecurity concerns. You can find entire CLE programs devoted to each of these topics, and of course we don't have time to go into any detail here, so just think of this as an issue spotter for you as you are doing your required vetting of vendors who provide GAI tools to assist you in your practice. The third and final legal ethics obligation we are going to discuss in the context of using GAI for document review is the duty to charge reasonable fees. We lawyers love our fees, and the ABA spends a lot of time in Formal Opinion number 512 talking about issues GAI tools can create relating to legal fees. The ABA begins by reminding us of the general ethical rule as it relates to fees, and makes clear that it applies with equal force to the use of GAI tools. Model Rule 1.5, which governs lawyers' fees and expenses, applies to representations in which a lawyer charges the client for the use of GAI. Rule 1.5a requires a lawyer's fees and expenses to be reasonable and includes a non-exclusive list of criteria for evaluating whether a fee or expense is reasonable. Rule 1.5b requires a lawyer to communicate to a client the basis on which the lawyer will charge for fees and expenses unless the client is a regularly represented client and the terms are not changing. The required information must be communicated before or within a reasonable time of commencing the representation, preferably in writing. Therefore, before charging the client for the use of the GAI tools or services, the lawyer must explain the basis for the charge, preferably in writing. This part is straightforward. If you are going to bill clients for the use of GAI tools or services, you need to tell the client how you will be charging them, ideally in your engagement letter or in some other written communication, such as your annual fee letter, before you start applying those charges. Where the rubber meets the road with regard to fees is what happens when your use of GAI tools allows you to become much more efficient in the provision of your legal services. Of course, that is one of the main benefits of GAI tools, and one of the main reasons clients are pressuring their lawyers to use GAI tools in their practices. But if a lawyer can now review and analyze 1,000 documents as part of a document review by using GAI tools in just 20 hours when it used to take the lawyer 40 hours, is the lawyer allowed to charge the client for the same 40 hours of work? The short answer, and as you might expect, is no. Quoting Formal Opinion number 512, GAI tools may provide lawyers with a faster and more efficient way to render legal services to their clients, but lawyers who bill clients an hourly rate for time spent on a matter must bill for their actual time. As ABA Formal Ethics Opinion 93-379 explained, the lawyer who has agreed to bill on the basis of hours expended does not fulfill her ethical duty if she bills the client for more time than she has actually expended on the client's behalf. If a lawyer uses a GAI tool to draft a pleading and expends 15 minutes to input the relevant information into the GAI program, the lawyer may charge for the 15 minutes as well as for the time the lawyer expends to review the resulting draft for accuracy and completeness. As further explained in Opinion 93-379, if a lawyer has agreed to charge the client on an hourly basis and it turns out that the lawyer is particularly efficient in accomplishing a given result, it nonetheless will not be permissible to charge the client for more hours than were actually expended on the matter, because the client should only be charged a reasonable fee for the legal services performed. The goal should be solely to compensate the lawyer fully for time reasonably expended, an approach that, if followed, will not take advantage of the client. So, you can only bill for the time you spent reviewing the GAI tool's output, and of course for time you spent testing that output to satisfy yourself that it is accurate and that important things were not left out, or worse still, created by the GAI tool out of whole cloth. What is clearly prohibited is billing for the time you would have spent reviewing 1,000 documents without the help of the GAI tool, and I think everyone understands that doing so would be unreasonable and therefore also unethical. What about fixed fee matters? How does the use of GAI tools to make your work more efficient apply in the context where you are not billing hourly? Let's say you agreed to bill a client $25,000 as a flat fee for a particular project. Before you had access to a GAI tool, it would typically take you 50 hours to complete the project. But using GAI, you estimate you can complete the project in just 25 hours, so roughly half the time. Are you still allowed to charge the client $25,000 as a flat fee for that project? The answer is, it depends, but probably not. Here is the ABA on the effect of GAI tools on flat fees. Quote, the factors set forth in Rule 1.5a also apply when evaluating the reasonableness of charges for GAI tools when the lawyer and client agree on a flat or contingent fee. For example, if using a GAI tool enables a lawyer to complete tasks much more quickly than without the tool, it may be unreasonable under Rule 1.5 for the lawyer to charge the same flat fee when using the GAI tool as when not using it. A fee charged for which little or no work was performed is an unreasonable fee. End quote. Based on this guidance, you would be required at a minimum to review the flat fee to see if you believe it to be reasonable. Now, if most other lawyers are still providing similar services for a flat fee of $25,000, You might be able to conclude that charging the client $25,000 is still a reasonable fee, but you'd probably want to think about reducing your fee to ensure that you are always on the reasonable and never the unreasonable side of a fee dispute. Of course, if other lawyers start lowering their fees as a result of efficiencies they have been able to find by using GAI tools, you'll likely need to lower your fees anyway to stay competitive, so it won't only be the requirements of ABA Model Rule 1.5 that will be putting gentle pressure on you to review your fixed fees in those cases. So we've covered hourly and fixed fee billing. What about passing the cost of GAI tools through to clients as reimbursed expenses? Is that kosher? Once again, the ABA's guidance is instructive. The principles set forth in ABA Formal Opinion 93-379 also apply when a lawyer charges GAI work as an expense. Rule 1.5a requires that disbursements, out-of-pocket expenses, or additional charges be reasonable. Formal Opinion 93-379 explained that a lawyer may charge the client for disbursements incurred in providing legal services to the client. For example, a lawyer typically may bill to the client the actual cost incurred in paying a court reporter to transcribe a deposition or the actual cost to travel to an out-of-town hearing. Absent contrary disclosure to the client, the lawyer should not add a surcharge to the actual cost of such expenses and should pass along to the client any discounts the lawyer receives from a third-party provider. At the same time, lawyers may not bill clients for general office overhead expenses, including the routine costs of maintaining a library, securing malpractice insurance, renting of office space, purchasing utilities, and the like. Formal Opinion 93-379 noted, in the absence of disclosure to a client in advance of the engagement to the contrary, such overhead should be subsumed within the lawyer's charges for professional services. The first thing that the ABA's guidance makes clear is that charges relating to GAI tools that are passed through to a client must be reasonable and must be passed through at the lawyer's cost with no markup. Where do GAI tools fall on the line between general office overhead that may not be passed through to clients and client or matter-specific charges that may be passed through? The answer generally turns on whether the GAI tool is generally used by the law firm for all clients, like a law library would be, and thus it would be considered overhead, or whether the law firm is using the tool to meet the needs of a specific matter, client, or group of clients, in which case it might be permissible to pass those costs through to the client or clients who benefited from the GAI tool. Here is the ABA on how to draw that line. Quote, in applying the principles set out in ABA Formal Ethics Opinion 93-379 to a lawyer's use of a GAI tool, lawyers should analyze the characteristics and uses of each GAI tool, because the types, uses, and cost of GAI tools and services vary significantly. To the extent a particular tool or service functions similarly to equipping and maintaining a legal practice, a lawyer should consider its cost to be overhead and not charge the client for its cost absent a contrary disclosure to the client in advance. For example, when a lawyer uses a GAI tool embedded in or added to the lawyer's word processing software to check grammar in documents the lawyer drafts, the cost of the tool should be considered overhead. In contrast, when a lawyer uses a third-party provider's GAI service to review thousands of voluminous contracts for a particular client, and the provider charges the lawyer for using the tool on a per-use basis, it would ordinarily be reasonable for the lawyer to bill the client as an expense for the actual out-of-pocket expense incurred for using that tool, end quote. So if your firm uses a GAI tool as a matter of course for all clients, think about a subscription to Google Gemini or Perplexity that all lawyers in the firm can use, just like they would use Google search to answer basic questions, then the costs of that GAI tool would be considered overhead. On the other hand, if your firm is paying for a GAI tool to help it review documents in cases that involve millions of pages of documents, and the law firm pays for the tool based in part on the volume of documents that are analyzed, the law firm might have a good case that those charges could be passed through to the client or clients on whose matters the GAI tool was used. If the charges can be passed through to the client in situations where a GAI tool is being specifically brought in or put to work for a particular matter, what rate should the lawyer charge the client for use of the GAI tool in that case? Recognizing that the question of how much to charge is perhaps the most difficult issue is determining how to charge clients for providing in-house services that are not required to be included in general office overhead and for which the lawyer seeks reimbursement. The ABA suggests that we look to some old technologies, photocopiers, and computer research services as a model for how to think about this in the context of GAI tools. In prior ethical opinions, the ABA had advised that lawyers may pass on reasonable charges for photocopying, computer research, and similar items, rather than absorbing these expenses as part of the lawyer's overhead, as many lawyers would do. For example, a lawyer may agree with the client in advance on the specific rate for photocopying, such as 15 cents per page. Absent an advance agreement, the lawyer is obliged to charge the client no more than the direct cost associated with the service, that is, the actual cost of making a copy on the photocopy machine, plus a reasonable allocation of overhead expenses directly associated with the provision of the service, for example, the salary of the photocopy machine operator. These same principles apply when a lawyer uses a proprietary in-house GAI tool in rendering legal services to a client. A firm may have made a substantial investment in developing a GAI tool that is relatively unique and that enables the firm to perform certain work more quickly or effectively. The firm may agree in advance with the client about the specific rates to be charged for using a GAI tool, just as it would agree in advance on its legal fees. But not all in-house GAI tools are likely to be so special or costly to develop, and the firm may opt not to seek the client's agreement on expenses for using the technology. Absent an agreement, the firm may charge the client no more than the direct cost associated with the tool, if any, plus a reasonable allocation of expenses directly associated with providing the GAI tool, while providing appropriate disclosures to the client consistent with Formal Opinion 93-379. The lawyer must ensure that the amount charged is not duplicative of other charges to this or other clients. That's a lot to swallow, but the gist is that you can charge clients for the use of GAI tools, both in terms of whatever cost the law firm paid to set up the technology and for use of the technology, as long as you obtain the client's agreement on how you plan to pass through those charges in advance. If you don't get the client's prior agreement, you can still pass through the charges, but they would be limited to the direct cost associated with the GAI tool, if any, plus a reasonable allocation of expenses directly associated with providing the GAI tool. In other words, you can charge them whatever the GAI tool charges you per document or gigabyte or whatever metric to review the client's documents, plus a reasonable allocation of whatever subscription or other fee the law firm is paying to have access to the GAI tool in the first place. So your options are to come up with a rate card for GAI tools, like the 15 cents a page for photocopying, and put it in your engagement letter, or just default to the direct charges plus a reasonable allocation of the subscription fee or other access charge. Needless to say, you can't double or triple dip by charging multiple clients for the same subscription fee. You would need to allocate the total subscription fee across all clients who benefited from the GAI tool, such that you are not being reimbursed any more than 100% of the subscription fee your law firm actually paid to the vendor. The last point on legal fees is, what about all of the time lawyers must spend to get up to speed on this new GAI tool? Is that billable client work? The ABA says the answer to that is a clear no. Finally, on the issue of reasonable fees, in addition to the time lawyers spend using various GAI tools and services, lawyers also will expend time to gain knowledge about those tools and services. Rule 1.1 recognizes that competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Comment 8 explains that to maintain the requisite knowledge and skill to be competent, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engaging in continuing study and education, and comply with all continuing legal education requirements to which the lawyer is subject. Lawyers must remember that they may not charge clients for time necessitated by their own inexperience. Therefore, a lawyer may not charge a client to learn about how to use a GAI tool or service that the lawyer will regularly use for clients, because lawyers must maintain competence in the tools they use, including but not limited to GAI technology. However, if a client explicitly requests that a specific GAI tool be used in furtherance of the matter, and the lawyer is not knowledgeable in using that tool, it may be appropriate for the lawyer to bill the client to gain the knowledge to use the tool effectively. Before billing the client, the lawyer and the client should agree upon any new billing practices or billing terms relating to the GAI tool and, preferably, memorialize the new agreement. So much like the time you are spending watching this CLE program and the 20 or so others that you will watch over the next 2-year CLE reporting cycle, you cannot bill a client for time getting up to speed on a GAI tool that you plan to use in your practice. The only exception is if the client requests some specific GAI tool or service and you agree in advance with the client on billing terms in that case. Because lawyers have an ethical obligation under ABA Model Rule 1.1 to keep abreast of changes in relevant technology, which duty now includes GAI tools that can affect the practice of law, you are required to acquire that knowledge on your own dime. Turning now to the second of the top 2 use cases of GAI by lawyers in 2025, let's talk about legal research. Let's hear from one of our legal colleagues on how GAI is being used in connection with legal research.
Back when I started, legal research meant long hours in the library or scrolling endlessly through online databases, carefully crafting search terms, and reading dozens of cases to find the ones that mattered. I'd manually summarize key rulings, check citations, and double-check interpretations to make sure I didn't miss a precedent. It was thorough work, and it ate up a lot of time that could have been spent advising clients or developing case strategy. Now, with GAI, I can enter a question or a factual scenario and get highly relevant case law, statutes, and even up-to-date legal commentary in a matter of minutes. GAI highlights the most pertinent passages, suggests key authorities, and drafts summaries I can quickly verify and adapt. I still need to review and validate the research results, but the process is dramatically faster and much less tedious. It lets me focus on the complex analysis and strategic thinking that my clients really value.
Clearly, legal research is one of the areas where GAI tools are already having a major impact on the practice of law in terms of increasing efficiency and effectiveness, but, as we saw at the outset, it is also the root cause of the 3 horror stories of lawyers getting in hot water because they used GAI tools for legal research in an irresponsible way. The integration of GAI tools in legal research is profoundly reshaping traditional methodologies by dramatically improving the speed, breadth, and depth of information retrieval. Where attorneys once relied predominantly on conventional databases and painstaking manual queries, GAI-powered research assistants now comb through vast repositories of case law, statutes, and secondary authority in seconds, surfacing relevant authorities, precedential trends, and nuanced distinctions that might have otherwise escaped detection. This immediacy permits lawyers to craft arguments more efficiently and to respond with greater agility to evolving legal questions, thus strengthening their capacity to provide timely, data-driven counsel to clients and stakeholders. GAI tools are also enhancing the quality and sophistication of legal research by supporting more contextual and semantic analysis. Modern GAI tools can assess the factual underpinnings and legal logic of a query, drawing parallels between disparate jurisdictions, identifying minority and majority positions, and offering recommended readings or lines of inquiry based on the practitioner's area of focus. This elevates the research process from a rote exercise in citation to a more dynamic, iterative engagement with legal doctrine. As a result, junior associates and seasoned litigators alike are increasingly empowered to uncover deeper insights, avoid blind spots, and construct more nuanced, persuasive arguments. When thinking about using GAI tools for legal research, let's start at the beginning, which is the question of how does a lawyer prompt the GAI tool to return the results you are looking for when you are conducting legal research? As we heard from our legal colleague, one option is to input the factual scenario that your client's case presents and ask the GAI tool to find cases that address that scenario in the relevant jurisdiction. Alarm bells should be going off in your head right now out of concerns about client confidential information, and that is the first ethical issue we are going to discuss in connection with this use case. Let's go to the ABA Informal Ethics Opinion number 512 to set up the issue of client confidentiality arising from the use of GAI tools. A lawyer using GAI must be cognizant of the duty under Model Rule 1.6 to keep confidential all information relating to the representation of a client, regardless of its source, unless the client gives informed consent, disclosure is impliedly authorized to carry out the representation, or disclosure is permitted by an exception. Model Rules 1.9c and 1.18b require lawyers to extend similar protections to former and prospective clients' information. Lawyers also must make reasonable efforts to prevent the inadvertent or unauthorized disclosure of, or unauthorized access to, information relating to the representation of the client. Generally, the nature and extent of the risk that information relating to a representation may be revealed depends on the facts. In considering whether information relating to any representation is adequately protected, lawyers must assess the likelihood of disclosure and unauthorized access, the sensitivity of the information, the difficulty of implementing safeguards, and the extent to which safeguards negatively impact the lawyer's ability to represent the client. Before lawyers input information relating to the representation of a client into a GAI tool, they must evaluate the risks that the information will be disclosed to or accessed by others outside the firm. Lawyers must also evaluate the risk that the information will be disclosed to or accessed by others inside the firm who will not adequately protect the information from improper disclosure or use because, for example, they are unaware of the source of the information and that it originated with a client of the firm. Because GAI tools now available differ in their ability to ensure that information relating to the representation is protected from impermissible disclosure and access, this risk analysis will be fact-driven and depend on the client, the matter, the task, and the GAI tool used to perform it. Okay, so what is clearly prohibited here? First of all, you can't open up any off-the-shelf GAI tool like Google Gemini or Perplexity. Enter all of the facts that seem relevant to your client's situation, which necessarily will include client confidential information and potentially also information subject to the attorney-client and/or attorney-work product privileges, and ask the GAI tool to find cases that address that scenario. This is critical, so let me state that again in no uncertain terms. No lawyer can input any client confidential information into a generally available GAI tool like Google Gemini or Perplexity without violating his or her duty to maintain client confidences under ABA Model Rule 1.6. Period. Full stop. Why is that? Because when you register for any of these services, they expressly warn you not to share any sensitive information in your conversations, and that if you nonetheless choose to do so, the terms of service for these GAI tools make it clear that the platform has no duty to protect that information. In light of these terms and the repeated warnings not to input any personal or sensitive information into these services, it's clear that a lawyer violates ABA Model Rule 1.6 by entering any client confidential information into one of the GAI tools as they are currently configured. You have not made reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client, if you enter client confidential information into Google Gemini, for example. In addition, you are not only running the risk of committing an ethical violation, you are also risking waiving the attorney-client privilege and/or attorney-work product protections if you disclose client confidential information. Assuming you have had conversations with your client that qualify for the attorney-client privilege, that is, communications that concern, seek, or provide legal advice, or you have created documents that reflect your legal analysis in anticipation of litigation, such that the attorney-work product protection might attach to those documents. Those communications must be kept confidential in order for those privileges to be maintained. Comment number 13 to ABA Model Rule 1.6 states in no uncertain terms that, quote, disclosure of any information is prohibited if it would compromise the attorney-client privilege or otherwise prejudice the client, end quote. If you were to input information you learned from confidential attorney-client communications or information contained in attorney-work product documents into a generally available GAI tool, that information has been disclosed and thus has not been kept in confidence. Indeed, it is highly likely in that scenario that such disclosure would be held to waive the attorney-client privilege and/or the attorney-work product protection as applicable. This is yet another reason why you must be extremely careful when you are thinking about using GAI tools to assist you in your law practice. Is there a workaround for this as it relates to using GAI tools for legal research? There are three possible solutions to the problem of disclosing client confidential information. First, you can prompt the GAI tool in ways that don't disclose any client confidential information. A narrow query that asks the GAI tool to find cases in the Southern District of New York where summary judgment was granted in cases involving copyright infringement claims based on an idea theft claim for a theatrical motion picture, likely would return useful precedents without the risk that you are disclosing any client confidential information. Obviously, complaints and other documents filed with the court are in the public domain, so limiting your queries to information that is contained in those documents is one way to ensure that you aren't including in your queries any client confidential information. Indeed, the ABA in Formal Ethics Opinion Number 512 expressly contemplates and recommends this approach. Today, there are uses of self-learning GAI tools in connection with a legal representation when client-informed consent is not required, because the lawyer will not be inputting information relating to the representation. As an example, if a lawyer is using the tool for idea generation in a manner that does not require inputting information relating to the representation, client-informed consent would not be necessary. So sticking just to generic or publicly available facts should be your default setting when you are entering information into queries for GAI tools. The second workaround, which is more theoretical than real when we are talking about using a generally available GAI tool like Google Gemini, is to obtain prior informed consent of the client. As the ABA noted in Formal Opinion Number 512, ABA Model Rule 1.6a provides that a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. But what would truly informed consent need to look like in this context? You'd need to explain in writing, and this would have to be an extensive writing and signed consent form to protect both you and the client, all of the risks of using a generally available GAI tool, including potential waivers of the attorney-client privilege and/or attorney work product protections that we have been discussing. It's hard to imagine any corporate or other sophisticated client agreeing to provide such consent once you explain how generally available GAI tools like Google Gemini handle information you supply to it in the prompts. Still, obtaining informed client consent prior to any such disclosure of client confidential information is one solve that ABA Model Rule 1.6 expressly provides. There is a more limited instance in which obtaining client consent might be practical, and we will discuss that next. The third solve is what many large law firms, companies, and government agencies are already doing, which is setting up their own confidential instance of a GAI tool that only has access to information and documents within that firm, company, or agency. The idea is to give the GAI tool, think of it as Google Gemini, but only for a particular law firm, for example, access to all of the firm's prior art, complaints, motions, legal memoranda, deposition transcripts, copies of cases, etc., and have that be the basis upon which the GAI tool is trained. So when you ask that your law firm's proprietary GAI tool to find cases in the Southern District of New York, where summary judgment was granted in cases involving copyright infringement claims based on an idea theft claim for a theatrical motion picture, it will pull only from complaints, memoranda, briefs, cases, and other useful documents that the firm itself previously has prepared on that topic for other firm clients, rather than pulling from the billions of publicly available data points that generally available GAI tools have access to. Maybe the results would suffer from the limited access, but maybe they would be better, because whatever results the confidential GAI tool would return would follow the firm's existing standards and precedents in creating new documents, rather than suffering from the garbage in, garbage out problem that generally available GAI tools often do. Indeed, you'll likely find a motion to dismiss that your firm prepared recently in just such a case that reflects your firm's standards and style, and would be a great place to start in terms of drafting the same motion in your case. In any event, the most important benefit of using a confidential instance of a GAI tool is that such a tool would not disclose client confidential information outside the firm. You'd enter that information into a prompt, but the law firm itself or a trusted vendor working for the law firm under a confidentiality agreement would manage the tool so there would be no outside disclosure. If you're interested in exploring something like this for your law firm, and while I am not an expert in this as it relates to law firm resources, my understanding is that Thomson Reuters CoCounsel and Microsoft Copilot are two such products that your law firm, company, or government agency might want to find out more about. As you probably know or might expect, the confidential instance of a GAI tool is the path that most law firms, companies, and governments are going down to ensure the protection of client confidential information, which makes perfect sense. There is, however, one important thing to consider if you are thinking about doing that, which is that ensuring that client confidential information isn't disclosed outside your law firm isn't the only thing you need to do to ensure that client confidential information isn't disclosed in violation of the legal ethics rules. The reason is that some client confidential information is subject to ethical screens within a law firm or government agency, and so you need to make sure that your confidential instance of a GAI tool maintains those ethical walls. The other reason is that client confidential information on one case can be returned as search results on another case. And even if there is no ethical wall problem, the lawyers on the other case might use the client confidential information in documents they create or briefs they file in their own cases, and thus inadvertently disclose that information. Here is the ABA explaining the problem as it relates to confidential instances of GAI tools. Self-learning GAI tools into which lawyers input information relating to the representation, by their very nature, raise the risk that information relating to one client's representation may be disclosed improperly, even if the tool is used exclusively by lawyers at the same firm. This can occur when information relating to one client's representation is input into the tool, then later revealed in response to prompts by lawyers working on other matters, who then share that output with other clients, file it with the court, or otherwise disclose it. In other words, the self-learning GAI tool may disclose information relating to the representation to persons outside the firm who are using the same GAI tool. Similarly, it may disclose information relating to the representation to persons in the firm, 1, who either are prohibited from access to said information because of an ethical wall, or 2, who could inadvertently use the information from one client to help another client, not understanding that the lawyer is revealing client confidences. Accordingly, because many of today's self-learning GAI tools are designed so that their output could lead directly or indirectly to the disclosure of information relating to the representation of a client's informed consent is required prior to inputting information relating to the representation into such a GAI tool. As I alluded to earlier, the problem of client confidential information inadvertently being disclosed and used within a law firm using a confidential instance of a GAI tool, which is much less than the risk of client confidential information being disclosed when a lawyer uses a generally available GAI tool, such as Google Gemini, is something that likely could be addressed by obtaining prior informed consent of the client. Thankfully, the ABA provides some useful guidance on how lawyers can obtain the required client consent in those situations. When consent is required, it must be informed. For the consent to be informed, the client must have the lawyer's best judgment about why the GAI tool is being used, the extent of and specific information about the risk, including particulars about the kinds of client information that will be disclosed, the ways in which others might use the information against the client's interests, and a clear explanation of the GAI tool's benefits to the representation. Part of informed consent requires the lawyer to explain the extent of the risk that later users or beneficiaries of the GAI tool will have access to information relating to the representation. To obtain informed consent when using a GAI tool, merely adding general boilerplate provisions to engagement letters purporting to authorize the lawyer to use GAI is not sufficient. Because of the uncertainty surrounding GAI tools' ability to protect such information, and the uncertainty about what happens to information both at input and output, it will be difficult to evaluate the risk that information relating to the representation will either be disclosed to or accessed by others inside the firm to whom it should not be disclosed, as well as others outside the firm. As a baseline, all lawyers should read and understand the terms of use, privacy policy, and related contractual terms and policies of any GAI tool they use to learn who has access to the information that the lawyer inputs into the tool, or consult with a colleague or external expert who has read and analyzed those terms and policies. Lawyers may need to consult with IT professionals or cybersecurity experts to fully understand these terms and policies, as well as the manner in which GAI tools utilize information. Once again, I think the analogy to email is instructive. Email creates a huge risk of disclosure of client confidential information, inadvertently adding opposing counsel to the recipient list of a draft brief being sent to your client is easy to do, and indeed, it happens with some frequency, and yet, nearly every client still wants their lawyers to email them drafts of briefs rather than sending them by facsimile. Who even has a fax machine anymore? or by Messenger if messengers even exist anymore. Some law firms, companies, and government agencies go the extra mile in terms of setting up secure websites where clients access draft briefs and other client confidential information that are undoubtedly more secure, but email is still ubiquitous for transmitting all manner of client confidential information between lawyers and their clients, and nearly all clients are on board with that because the benefits greatly outweigh the risks. The same is true with regard to lawyers using confidential instances of GAI tools. The benefits vastly outweigh the risks, and so I expect lawyers will be able to obtain prior informed consent of their clients to use the platforms. I read the ABA's guidance in Formal Opinion number 512 as endorsing this approach as it relates to confidential instances of GAI tools, while at the same time correctly viewing generally available GAI tools like Google Gemini or Perplexity as platforms that lawyers should not be asking their clients to consent for them to use, because they expressly offer no protection for client confidential information. The second ethical issue that using GAI tools for legal research raises is the obligation of candor toward the tribunal and the duty not to make frivolous claims. In Formal Opinion number 512, the ABA reminds us that lawyers using GAI in litigation have ethical responsibilities to the courts as well as to clients. Model Rules 3.1, 3.3, and 8.4c may be implicated by certain uses. Rule 3.1 states in part that a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law or fact for doing so that is not frivolous. Rule 3.3 makes it clear that lawyers cannot knowingly make any false statement of law or fact to a tribunal or fail to correct a material false statement of law or fact previously made to a tribunal. Rule 8.4c provides that a lawyer shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Even an unintentional misstatement to a court can involve a misrepresentation under Rule 8.4c. Therefore, output from a GAI tool must be carefully reviewed to ensure that the assertions made to the court are not false. Issues that have arisen to date with lawyers' use of GAI outputs include citations to non-existent opinions, inaccurate analysis of authority, and use of misleading arguments. Some courts have responded by requiring lawyers to disclose their use of GAI. As a matter of competence, as previously discussed, lawyers should review for accuracy all GAI outputs. In judicial proceedings, duties to the tribunal likewise require lawyers, before submitting materials to a court, to review these outputs, including analysis and citations to authority, and to correct errors, including misstatements of law and fact, a failure to include controlling legal authority, and misleading arguments. When the ABA says that, quote, issues have arisen to date with lawyers' use of GAI outputs, end quote, it is talking about the 3 horror stories that I mentioned in the beginning. Those lawyers violated their duties of candor to the court and to avoid making frivolous claims, and you certainly don't want to be like them. Thankfully, the solve for this is easy. You must check every authority that you obtain from a GAI tool for accuracy before you rely upon it and long before you think about citing it in a brief you file with the court. GAI tools can be a great way to start your research in terms of finding cases, suggesting arguments, etc., but they can never be the end of your research. I would note that using a confidential instance of a GAI tool mitigates the risk that a query you enter will produce cases or briefs or memoranda that are fake because the tool is pulling from your firm or organization's own prior art, briefs that were written for other clients, copies of cases found by other researchers, and the like. It doesn't eliminate it, and so you still need to check 100% of the output you receive from any GAI tool. I'm not sure that if you ask your confidential instance of a GAI tool to find you a case that says X, that tool will respond that it cannot find such a case instead of simply making one up that looks a lot like the other cases that exist in the training set for the GAI tool. There is also the fact of human error. Don't forget that the training set for your firm or organization likely includes all of the briefs, legal memoranda, etc. that have ever been generated, and the GAI tool can't tell what is true from what is false, or what is accurate and what is not. So, if a summer associate wrote a legal memorandum on a topic, maybe on his last day at the firm and after having had 2 martinis at a boozy summer associate lunch, let's say the conclusions in that memorandum might not be accurate. Just because a confidential instance of a GAI tool pulls only from your firm or organization's own prior art doesn't mean that work product is 100% accurate. You'll want to check it for yourself before you rely upon it in the representation of your clients, and surely before you attach your name to it in a brief that is filed with a court. Your clients have every right to expect that level of conscientiousness, because that is exactly what they are paying you for. While cutting corners is always a temptation, particularly when you are working as hard as you undoubtedly are, your law license is a precious thing for which you have dedicated years of your life, and trust me when I say that you never want to be the next poster child for the misuse of GAI tools. Turning now to the last of the top 3 use cases of GAI by lawyers in 2025, let's talk about document summarization. Let's hear from one of our legal colleagues on how GAI is being used in connection with document summarization.
When I first started practicing, summarizing documents was a huge part of my day. I'd read long contracts, court filings, or discovery documents line by line, jotting down key points and organizing summaries to brief clients or colleagues. It was slow work, sometimes hours spent condensing a single agreement or filing, and I always worried about missing a crucial detail or nuance. Now with GAI, I can upload a document and, within minutes, get a clear, concise summary that highlights the main clauses, obligations, or facts. GAI points out what's most important and even flags unusual terms or risks, so I can focus on reviewing and refining instead of starting from scratch. It frees up my time for deeper analysis and client strategy, while still letting me ensure the final summaries are accurate and tailored to each situation.
Document summarization is another area where GAI tools are already having a major impact on the practice of law in terms of increasing efficiency and effectiveness, particularly in the realm of information management and preliminary analysis. Lawyers have long been burdened with the task of manually reviewing voluminous records in litigation, regulatory, and transactional settings, a process that is both time-intensive and susceptible to human error. With the advent of GAI tools, practitioners can now rapidly distill thousands of pages into concise narratives, highlighting pertinent facts, legal arguments, and substantive issues. This technology not only streamlines case preparation and document review, but it also enhances the ability of attorneys to focus on strategic decision-making and substantive advocacy. In addition to increased efficiency, the deployment of GAI tools for document summarization offers opportunities for improved accuracy and consistency in legal documentation. These tools, which can be trained on diverse data sets, can identify patterns, extract standardized clauses, and flag inconsistencies that might otherwise be overlooked in manual review. As firms adopt workflows integrating GAI-driven summaries, junior lawyers and paralegals are empowered to engage more substantively with case materials at an earlier stage, elevating the overall quality and reliability of legal output. Moreover, the ability to produce plain language summaries tailored to different audiences, including clients, courts, or internal stakeholders, serves to enhance communication and transparency throughout the legal process. Of course, as with the other 2 use cases we have discussed today, the use of GAI tools for document summarization brings new ethical challenges. In addition to the legal ethics issues we already have talked about in connection with the other 2 use cases, the final legal ethics issue we are going to discuss today is the duty to communicate relevant information to our clients under ABA Model Rule 1.4. The ABA Committee's guidance in Formal Ethics Opinion number 512 on this point provides as follows. Where Model Rule 1.6 does not require disclosure and informed consent, the lawyer must separately consider whether other model rules, particularly Model Rule 1.4, require disclosing the use of a GAI tool in the representation. Model Rule 1.4, which addresses lawyers' duty to communicate with their clients, builds on lawyers' legal obligations as fiduciaries, which include the duty of an attorney to advise the client promptly whenever he has any information to give, which it is important the client should receive. Of particular relevance, Model Rule 1.4a2 states that a lawyer shall reasonably consult with the client about the means by which the client's objectives are to be accomplished. Additionally, Model Rule 1.4b obligates lawyers to explain matters to the extent reasonably necessary to permit a client to make an informed decision regarding the representation. Comment number 5 to Rule 1.4 explains, the lawyer should fulfill reasonable client expectations for information consistent with the duty to act in the client's best interests and the client's overall requirements as to the character of representation. Considering these underlying principles, questions arise regarding whether and when lawyers might be required to disclose their use of GAI tools to clients pursuant to Rule 1.4. Unfortunately, after having set up the issue, the ABA committee fails to provide much in the way of concrete advice to lawyers about whether their use of GAI tools is something that needs to be disclosed to a client, opting instead to leave it to lawyers to figure it out on a case-by-case basis. Here is what the ABA says in that regard. The facts of each case will determine whether Model Rule 1.4 requires lawyers to disclose their GAI practices to clients or obtain their informed consent to use a particular GAI tool. Depending on the circumstances, client disclosure may be unnecessary. Of course, lawyers must disclose their GAI practices if asked by a client how they conducted their work, or whether GAI technologies were employed in doing so, or if the client expressly requires disclosure under the terms of the engagement agreement or the client's outside counsel guidelines. There are also situations where Model Rule 1.4 requires lawyers to discuss their use of GAI tools unprompted by the client. For example, as discussed in the previous section, clients would need to be informed in advance and to give informed consent if the lawyer proposes to input information relating to the representation into the GAI tool. Lawyers must also consult clients when the use of a GAI tool is relevant to the basis or reasonableness of a lawyer's fee. Client consultation about the use of a GAI tool is also necessary when its output will influence a significant decision in the representation, such as when a lawyer relies on GAI technology to evaluate potential litigation outcomes or jury selection. A client would reasonably want to know whether, in providing advice or making important decisions about how to carry out the representation, the lawyer is exercising independent judgment or, in the alternative, is deferring to the output of a GAI tool. Or there may be situations where a client retains a lawyer based on the lawyer's particular skill and judgment, when the use of a GAI tool without the client's knowledge would violate the terms of the engagement agreement or the client's reasonable expectations regarding how the lawyer intends to accomplish the objectives of the representation. Okay, so to summarize, there are a few situations where a lawyer must disclose to a client that the lawyer is using GAI tools, even if the client doesn't ask. Those cases are where informed consent of the client is required under ABA Model Rule 1.6, such as when a lawyer seeks the client's prior written consent to input client confidential information into a proprietary instance of a GAI tool, or where the lawyer's use of a GAI tool is relevant to how the lawyer is charging for the lawyer's services, such as when a lawyer chooses to pass through an allocated portion of the subscription charge for access to a GAI tool that is being used for the client's matter and/or usage-based charges incurred using that GAI tool for the client's matter. We have discussed both of these situations in detail already, and of course it makes sense in both of them that the lawyer would need to inform the client of the lawyer's use of GAI tools as required by ABA Model Rule 1.4. The other use case the ABA references when a lawyer uses a GAI tool to help the lawyer make a significant decision in the representation, such as when a lawyer relies on GAI technology to evaluate potential litigation outcomes, or jury selection, also makes good sense. Let's say you use a GAI tool to run a simulation of potential jury verdicts or settlement outcomes for your case, and then you rely on the result of that simulation to recommend to the client whether to go to trial or whether to settle, and if to settle, on what terms. Because you wouldn't want the client to think your advice in this regard is based solely on your own experience handling similar cases or in researching jury verdicts or settlements the old-fashioned way. This is the kind of use of a GAI tool that you certainly would want to disclose to the client. Remember, while GAI tools can be highly efficient and accurate means of performing factual research, they also can make up results just like the GAI tools that invented the court opinions that some careless lawyers used in the briefs that they filed with the court, much to their peril. Not only would you need to guard against that risk by performing due diligence and then checking the output for errors before relying on a GAI tool to simulate litigation or settlement outcomes, you'd need to disclose the use of the GAI tool to your client to make sure you've complied with your duties under ABA Model Rule 1.4 to, quote, reasonably consult with the client about the means by which the client's objectives are to be accomplished and explain matters to the extent reasonably necessary to permit a client to make an informed decision regarding the representation, end quote. The final situation that the ABA highlights, which I think should be obvious to all without much explanation, is the need to disclose the use of a GAI tool to a client when the lawyer has been retained by the client based on the lawyer's particular skill and judgment, but where the lawyer is using the GAI tool to enhance or worse still, to provide that particular skill or judgment. Think of a lawyer who has been retained to litigate a patent infringement case, but the lawyer has no prior experience litigating patent cases. It would be unethical for the lawyer to accept the representation with the intention of using a GAI tool to supply the missing skill and experience in patent matters. Specifically, the lawyer would be violating both his or her duty of competence under ABA Model Rule 1.1, as well as the duty to communicate relevant information to the client under ABA Model Rule 1.4. Again, I think this should be obvious to all, but as GAI tools become more and more sophisticated, you can imagine a general litigator a year or two from now saying to himself, I know litigation and I can use this GAI tool to teach me everything I need to know about patents so I can take this case and the client won't be any wiser. Needless to say, you should resist that temptation. The only proper way to proceed in that case is for the lawyer to associate with another lawyer who has the necessary patent expertise, or failing that, to decline the representation. While you could follow the requirement of ABA Model Rule 1.4 and disclose your plan to the client and seek the client's prior informed consent, I doubt many clients with a high-stakes patent litigation would be willing to proceed on that basis. Stepping back from the specifics, this is exactly why we have the legal ethics rules. They take important decisions out of the hands of lawyers, who in some cases are too willing to think we can do things that a reasonable person would know we cannot do, and put those decisions in the hands of our clients following full disclosure of the facts that would allow the client to make an informed decision. Are these the only circumstances where a lawyer's use of a GAI tool requires disclosure to the client? As I mentioned before, the answer is no, and the ABA says that it is something a lawyer must consider in every case on a case-by-case basis. Quoting once again from Formal Ethics Opinion Number 512, it is not possible to catalog every situation in which lawyers must inform clients about their use of GAI. Again, lawyers should consider whether the specific circumstances warrant client consultation about the use of a GAI tool, including the client's needs and expectations, the scope of the representation, and the sensitivity of the information involved. Potentially relevant considerations include the GAI tool's importance to a particular task, the significance of that task to the overall representation, how the GAI tool will process the client's information, and the extent to which knowledge of the lawyer's use of the GAI tool would affect the client's evaluation of or confidence in the lawyer's work. Even when Rule 1.6 does not require informed consent and Rule 1.4 does not require a disclosure regarding the use of GAI, lawyers may tell clients how they employ GAI tools to assist in the delivery of legal services. Explaining this may serve the interest of effective client communication. The engagement agreement is a logical place to make such disclosures and to identify any client instructions on the use of GAI in the representation. In short, the ABA says that disclosure is required in the enumerated cases, asks lawyers to consider it in every other case, and reminds us that permissive disclose is always available and likely a good idea. While this advice isn't as definitive as we might like, it's hard to argue with more disclosure to clients, particularly as it relates to new and quickly evolving technologies like GAI tools, so I would add my voice to the ABA's in recommending more disclosure rather than less in this area. So where does all of the ABA's guidance about the duty to inform clients leave us with regard to our third use case? Using GAI to summarize documents? Are lawyers obligated to disclose to their clients that they are using GAI to assist them with that aspect of their legal representation? I think you could make a strong case that reviewing and summarizing important documents such as contracts, which historically has been part and parcel of what clients expect their lawyers to do, is a case where lawyers should inform their clients of their intention to use GAI to assist in the performance of that task. While I suppose you could make a distinction between the review of insignificant contracts by GAI that might not require disclosure to the client and the review of key contracts by GAI that would require disclosure, I suggest that lawyers err on the side of more disclosure rather than less, particularly when we are talking about new technologies like GAI. Much of the disclosure that is required could be added to your standard engagement letter, which would add protection for the lawyer in the event a legal ethics issue is raised later without imposing much of an additional burden either on the lawyer or the client. That said, a lawyer who outsourced the review of key contracts in a business dispute to a GAI tool without informing the client that he or she was doing so would be unlikely to escape potential liability under the legal ethics rules merely by pointing to boilerplate language in an engagement letter that GAI tools might be used to summarize some documents. In summary, use your best judgment about when to inform a client of your use of GAI tools to summarize documents in connection with your representation. And if you are relying to GAI tools to summarize key documents, make sure you inform the client and get the client's consent before doing so. Another common way that lawyers are already using GAI tools to summarize documents is for deposition and hearing transcripts. The ability to upload thousands of pages of transcripts into a GAI tool and to have that tool spit out concise summaries of a deposition or court hearing in just a few seconds is a marvelous use of the technology. It benefits both the lawyers, particularly the more junior lawyers to whom the task of reviewing those transcripts and creating those summaries traditionally would fall, and the clients, who are no longer paying for the many hours these more junior lawyers spent engaged in that task. Of course, there are many benefits to having lawyers review transcripts, such as picking up on nuances that the GAI tool might miss, and in training those lawyers who learn how to take a deposition or conduct themselves in court by observing how other lawyers perform those tasks. But much like email, the benefits of using GAI tools to summarize deposition and court transcripts far outweigh the loss of those training benefits, and for that reason, it will continue to be the go-to way that lawyers perform this task going forward. So does using GAI tools to summarize deposition or court transcripts require disclosure to the client under ABA Model Rule 1.4? Based on the guidance set out in ABA Formal Opinion number 512, I think the answer, unfortunately, is it depends. If you are talking about summarizing the deposition transcripts of relatively low-level witnesses or court hearings involving discovery issues, you probably could conclude that using GAI tools to summarize those transcripts would not rise to the level of requiring disclosure to the client. On the other hand, relying solely on GAI tools to summarize the depositions of key witnesses or transcripts of a hearing on summary judgment with no actual review of those transcripts by a lawyer probably wouldn't be a good idea because of accuracy concerns. But even if you chose to do that, you'd need to disclose that to your client. Once again, we are relying on lawyers to use your sound judgment when it comes to client disclosure. Asking yourself, is this something my client would want to know? If the answer is yes, err on the side of disclosure. This is good advice in general and with regard to GAI tools in particular. Finally, and before we close our discussion of our third use case, I want to remind you that the three ethical obligations we discussed in connection with our first use case, document review, apply with equal force to using GAI tools in assist with legal research, just as they applied to our third and final use case, document summarization. The duty of competence, the duty to supervise lawyers and non-lawyer staff, and the obligation to charge only reasonable fees should be top of mind when you are thinking about using GAI tools to assist you with legal research. A lawyer who uses GAI tools to find cases but doesn't check those cases violates his duty of competence under ABA Model Rule 1.1, just as a supervisory lawyer who simply takes those cases from a more junior lawyer without confirming that the lawyer had checked them or checking them herself violates her duty to supervise lawyers under ABA Model Rule 5.1, just as a lawyer who bills a client for the time he would have spent researching an issue instead of the time he actually spent with the help of a GAI tool violates this duty to charge only reasonable fees under ABA Model Rule 1.5. We're very close to the end of today's presentation. Before we close, let's recap what we covered today. First, we talked about the fact that more lawyers than ever before are using GAI in their practices, and this is true across lawyers in private practice, in-house, and government. We looked at the 5 key findings of the Thomson Reuters Institute report, which were number 1, that steady usage of GAI is increasing, number 2, that GAI is soon to be central to legal workflows, number 3, that lawyers are maintaining positivity about GAI, number 4, that many business questions about GAI still remain, and number 5, that policies and training on the use of GAI tools are still needed. We then transitioned into talking about the helpful guidance that the ABA and influential state bar associations in California and New York have issued about how to use GAI tools without violating our legal ethics obligations. The most important guidance was the ABA Standing Committee on Ethics and Professional Responsibility that in July 2024 issued Formal Opinion number 512 entitled Generative Artificial Intelligence Tools. This formal ethics opinion represented a huge step forward in identifying the legal ethics issues that can arise when lawyers use GAI and providing guidance on how to navigate those issues. The ABA's guidance was particularly useful in helping us to work through the top 3 ways that lawyers are using GAI tools in 2025. As a reminder, those use cases are number 1, document review, number 2, legal research, and number 3, document summarization. We then examined each of these use cases in some detail, showing how each task was accomplished by lawyers before GAI and how lawyers today are performing those same tasks with the help of GAI tools before we turn to the legal ethics issues that are raised by the use of those GAI tools. Across the 3 use cases, we talked about our obligations to provide competent representation, to supervise legal and non-legal personnel, to charge reasonable fees, to preserve client confidential information, to be candid toward the tribunal, and to communicate relevant information to our clients. It is important to remember that all of these ethical obligations are present whenever we practice law. And thus, when we think about using GAI tools in any of the 3 use cases, even if we only discussed certain of the legal ethics obligations in connection with only one of the use cases, primarily to avoid duplication and for emphasis, we need to remember to consider the other legal ethics obligations in connection with that use case as well. While in some instances we could fault the ABA for not providing more specific guidance as it relates to a particular use case involving GAI tools, overall the ABA did a good job of providing practical and useful guidance, and perhaps as importantly, by providing it relatively early so that lawyers can benefit from it as we are continuing to expand our use of GAI tools in our practices. I contrasted this with the situation lawyers faced during COVID when remote work became the norm, which allowed and perhaps even encouraged lawyers to move to states where they were not admitted to practice, since they could continue to practice in their home jurisdiction remotely, where the ABA did not provide guidance or change the legal ethics rules relating to the unauthorized practice of law to allow for remote work until several years after the fact. That left many lawyers in an awkward position, living and working as lawyers in a state where they were not a member of the bar, until the ABA finally stepped in to provide guidance, make changes to the ABA model rules, and persuade individual states to amend their legal ethics rules as the ABA was recommending. At least with regard to GAI tools, we have ample guidance from the ABA and influential state bars in California and New York that we can use today to help us navigate these tricky waters prospectively as opposed to having to figure things out largely on our own, and thus at our potential peril. I would also compliment the ABA on taking a very reasonable and pragmatic approach in its guidance as opposed to other rules and guidance it has issued over the years with which I tended to disagree. To my mind, as far as GAI tools are concerned, the ABA wants lawyers to use them because of the many efficiencies and improvements in results those tools can drive, and in recognition that our clients want us to use them for the same reasons. And the focus is solely on how do we minimize the risks of that usage in terms of inaccurate legal advice, making misrepresentations to a court, disclosure of client confidential information, etc. While I am sure the ABA's advice will evolve over time as we all get more experience using GAI tools, and perhaps the ABA will be forced to backtrack if we have still more horror stories of lawyers who have been burned by using GAI tools, but at least the ABA is starting from the place of wanting to support lawyers who use GAI tools in their practice, as opposed to trying to prevent their use, or even worse, laying traps for the unwary by interpreting the legal ethics rules in ways that don't comport with how responsible lawyers are already using GAI tools in 2025. We've reached the end of our program today. To close, I'll quote once more from Formal Opinion number 512 to provide the key takeaways from today's presentation on the latest guidance for using GAI tools in your practice. Quote, lawyers using GAI tools have a duty of competence, including maintaining relevant technological competence, which requires an understanding of the evolving nature of GAI. In using GAI tools, lawyers also have other relevant ethical duties, such as those relating to confidentiality, communication with a client, meritorious claims and contentions, candor toward the tribunal, supervisory responsibilities regarding others in the law office using the technology and those outside the law office providing GAI services and charging reasonable fees. With the ever-evolving use of technology by lawyers and courts, lawyers must be vigilant in complying with the rules of professional conduct to ensure that lawyers are adhering to their ethical responsibilities and that clients are protected. End quote. I hope you enjoyed today's program. Thanks for joining me.